Uh, since we know that tomorrow being Raksha Bandhan, all are in festive mood. So post lunch session, I'll try to just keep you engaged in this particular topic. Since if you all know what the topic is about, it basically tells you regarding the role and responsibilities of authorized representative. So when this was told to me that I have to prepare a topic on authorized representative, the thing which came to my mind is what can be taken for 3 hour long session. So broadly, it is the theoretical part. Who is a authorized representative? How and what are his or her responsibilities? How he can cater to the best of the value maximization which is possible in the IBC. So we are not restricting to that just because it came to my mind. And when I was thinking about this topic, I have prepared the whole of my stuff in two parts. Basically, one, wherein as an insolvency professional, if I want to enter into a new opportunity, if I want to grab this kind of new opportunity, wherein I can now play a role of authorized representative. So, what are the things which I should be aware of? What is the law exactly? What are my role and responsibilities being a authorized representative? So, even if you have not taken up any assignment as an insolvency professional, now again you can look up to this thing as a new professional opportunity wherein you can become an authorized representative in any of the assignments, and thereby you can very well connect with a lot of people, and obviously it will get you more and more deeper perspective into the IBC, and sooner or later you will also get the assignments as IP. That is one aspect to look into it. The second aspect would be, being an insolvency professional, how can I leverage the expert or the person who is available as an authorized representative? Because being an insolvency professional, like if I'm a resolution professional or IRP in any of the assignments, I want to speed up my work. How can I leverage the person who is already there, who is also a professional person? Besides getting into the chaos of the creditors, it's better to connect with the authorized representative, tell him the whole situation, get sit with him, or maybe you can we can discuss the things more with the professional people. So how I can leverage someone who is already there in the role of authorized representative? How can we synergize the energies of these two people? So being an insolvency professional, how can I take advantage of the authorized representative? That is the second aspect to look into today's session. So again, I'm just repeating it for the sake of any persons who have recently joined. So don't take up this session just as a theoretical session. Just look into as if you have a new career opportunity for yourselves of becoming an authorized representative somewhere. So if you have this kind of thing in your mind, then what are the various aspects you need to think upon? What are the various aspects you have to be aware of? That is what we will be dealing here. And why I'm again and again saying that this can be a very good professional opportunities, because if you look up to the petitions which are filed, mostly they are the applications which are filed, which they most of them are with respect to these real estate cases. So then the if we check the overall scope, how much is the scope for an authorized representative, you will really find that there are huge number of cases wherein you can enter into just like a authorized representative, and you can cater your services there as well, rather than just sitting and waiting for some assignment to come up in your name as an insolvency professional. So that could be another opportunity for all of you which we can think upon in this session. And obviously the second part would be, if you are already doing some assignment and there there is a possibility to appoint authorized representative, and when that person is appointed, how you can take benefit from his services. So what is something which you need to know to get benefit out of his or from the authorized representatives services. So that could be the aspect with which you should actually look into this session altogether. So before I start, I'll just share my presentation. Just let me know if it is visible. Is my screen visible?
Yes,
Okay, okay. So before I start, I just wanted to know whether any one of you has acted like an authorized representative anywhere? Any challenges you faced? If you want to share your experience before we start the session. Has any one of you ever been the authorized representative? No? Okay, never mind. We'll just start off the session. See, this concept of authorized representative is basically when you are representing uh, 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 a lot of people as such. So, if I talk about Companies Act, therein we have a person known as proxy, a member who is there in the company. He has a right to appoint proxy. If he does not want to go on, if he is unable to attend the meeting, he can send on his behalf some other person. He can attend the meeting and he will be known as a proxy. Then if a person is attending meeting on your behalf, what are his rights and responsibilities? So in Companies Act, you might have all read about the term proxy, what are his rights, and whether one proxy can attend the meeting on behalf of more than one person. So we have seen that in Companies Act that for 50 people, a proxy can become a proxy for them also. So that kind of concept is already existing in many laws, that instead of you going anywhere, you can have your authorized representative. And being a professional, we already know, being a lawyer, chartered accountant, or company secretary, we already know that on behalf of our clients, we can represent them at various forums. So that way, this whole idea of authorized representative has been there in many of the laws, and now it is also there in IBC. So, what is the exact role of authorized representative here? Whom this person is representing? What is the eligibility criteria of becoming an authorized representative? Whether he will be given right to vote or not? Can he file an appeal or something if any injustice is happening for the people whom he is representing, or the financial creators he is representing? So that is what we will all talk about in today's session. So broadly, if you just want to have a quick summary of it, it will be like we have to study a few sections which are relevant for this authorized representative. Simultaneously, we will study the CIRP regulations as well, wherein the role of AR is being discussed. Specifically, it is 16A. And then we will discuss what is the function of AR in the COC meetings, and how does he play a very effective role in every aspect. We will check all that. So let us start the session. Who is authorized representative? If I talk about who is an authorized representative, whether there is any definition given in the code or anywhere, as can anyone say, is there any definition given in the code? Actually, there is no definition of this authorized representative. There is only the eligibility criteria which is given, who can become the authorized representative and what are his role and responsibility. So that way it is given in the code and the regulation. So there is no proper definition, but we can summarize it in such a way that authorized representative is basically a registered IP. So who can become an authorized representative? First of all, only and only an insolvency professional who is registered can become an authorized representative. So what do you mean by registered IP? Registered IP, simply means he is either registered with any of the IPAs, maybe with CS Institute or CA Institute, like that. He should be registered somewhere. He should have a proper registration number. That is the thing. And he should also hold a valid AFA. So that is also a criteria. So who is an authorized representative? We will say that an authorized representative is a registered insolvency professional who is appointed to represent a class of financial creditors, for example, home buyers, deposit holders, etc., in the COC meetings. So basically, why this person is coming into picture, he will be representing a whole lot of people, a whole lot of set of people. Like in case of real estate cases, you have n number of home buyers. So if all of them go to a meeting, there will be a kind of chaos. So in order to curtail that kind of situation, what is mentioned in the law here is that to represent those home buyers, they can send just one person who will be speaking for them, or maybe who will raise their concerns. So in order to avoid that kind of situation wherein all the home buyers or all the deposit holders cannot attend the meeting at one place, maybe, so that is something is that is why this whole concept is being introduced for this authorized representative. So basically, the idea is this authorized representative will be attending meetings on behalf of these home buyers or deposit holders or any of the other financial. The term which is very important here is class of financial creditors. So what do you mean by class of financial creditor? That will be discussed in later part. But for the time being, we must understand that here, whenever we are saying the term authorized representative, it generally means that a person who is an IP, who is a registered IP, is basically appointed to represent a class of financial creditors in the COC meetings. And this person comes into picture only when there are numerous or fragmented creditors. So there are various or there are numerous creditors who cannot be taken upon at one place, and maybe there will be a lot of chaos if you keep on asking them to come. So that is why to have a smooth procedure, basically this concept is being introduced. So the framework is established under section 21(6)(a) and organized and operationalized via this regulation 16(a) of the CIRP regulations. There are AR appointments for debenture holders and fixed depositors as well. So normally we all understand that through Companies Act there is a provision that for if you have a particular number of debenture holders, then you should have a debenture trustee to represent them, and the debenture trustee attends the meeting on their behalf. So that in that sense, he is also an authorized representative. Similarly, in case of fixed deposit holders, they also have this kind of facility available. But in case of real estate companies, the numbers and the complexities are perceived much higher, and therefore there is a requirement to have a proper procedure, proper guideline, rules and regulations for this authorized representative to help out the situation in a very, or to make the situation very clear and very smooth process. So as I've just said in the beginning also, that this can become a very good professional opportunity. If we have not seen it that way, it can be taken up as a professional opportunity as well. So becoming an authorized representative can again give you a lot of insight into the IBC assignments, and then again it will create a lot of networking with the people who are already engaged in that field, and you will have communication also with people who are the actual stakeholders. So that way it can be a very challenging professional opportunity. So why we are saying that it can be a challenging or an emerging professional opportunity? Because there is an increase in the class creditor cases. So there is growth in real estate CIRPs, that is home buyers, etc. NBFC's failure, that is in case whom we call depositors, and the bond defaults, that is non-convertible debenture holders, they are, so all these are uh, adding up to the cases wherein you can have this presence of authorized representative. So this has led to more and more authorized representative appointments, because there are many cases involving this real estate or NBFC failures and things like that. Next reason could be there is steady CIRP cost income. So AR's fees is paid from the CIRP cost, which is approved by COC, making it a secure payment stream. So just like we know that the RP's cost is also a part of CIRP cost and it will be paid in priority. Similarly, the authorized representative fees is also coming into the priority thing only in the waterfall mechanism. So that will be paid out first. Next, so it will also build your reputation because you are representing so many people. So again, there will be a communication between you and various home buyers. So you will also understand their concerns. You will be able to represent them. So that will help you out in making your reputation very strong in front of others. So performing well as an authorized representative strengthens your profile for future RP and IRP roles and other IBC assignments as well. It will obviously enhance your network. So AR interacts closely with creditors, COC, RPs, and legal teams, and it will obviously help in overall business development. So if I talk about taking it as a professional opportunity, what is the skill set required? So let us understand what is the skill set required in this case. So first of all, you should have the IBC legal knowledge. So what are the various legal provisions with respect to this authorized representative? What are the regulations associated with it? So we need to understand the overall aspect, and that is why we are having this session. And I'll take you through all the relevant things which are required to understand this concept. Also, we will discuss some case laws, the judgments, which are specifically for this authorized representative to help you understand the concept better. So especially we need to understand section 21, subsection 6A, then section 25 capital A, regulation 16 capital A, COC voting rules. So all this we need to understand thoroughly if we really want to get into the shoes of authorized representative. Next is mass communication skills. So if you think you are strong in communication skills, this is a very good opportunity for all of you. So if you are able to explain complex plans to large and diverse creditors class, obviously this role really suits you. Then next skill set which is required is regarding the data management. Managing the large creditors list, voting shares, maintaining audit proof records. So that is a very cumbersome process if you see altogether, because it will not be the RP or IRP who will now be engaged in this maintenance of documents and all. Now it will be the task of the authorized representative to get into touch with all the creditors for the particular class of creditor for whom he is being appointed. He has to take care of the voting share, how much is the voting share for each. He has to list down everything. He has to maintain the proper records, audit proofs, etc. So everything he has to maintain. It's not that he's just representing and just moving out. He also has to document everything very smoothly. So that is another kind of skill set which this authorized representative should have. Then obviously, since a lot of documentation work is there, a lot of, because we have to do everything in time also. So it is very required, and it is the need of the hour to become tax savvy. So you have to have some kind of technology knowledge so that you can apply it in your day-to-day activities in order to run this whole process smoothly. So use of AI tools, online voting platforms, WhatsApp or IBR outreach, you should be able to understand all that. You should be able to use that, and you should make the other people also understand how these tools are working and these are giving the proper report. So that there is no confusion in the minds of others also. Next, you should be able to handle the conflict very, very smoothly. So if you have this ability of conflict handling, then obviously you are the best person to be appointed as authorized representative. So mediation between dissenting voices without bias, that is what is required as a very, very important skill set to become this authorized representative. Okay, now let's understand what we will discuss in this whole session and how I have designed it. So first we will understand the background why authorized representative concept is built in. Though we know about it, but let us get into the actual facts and what were the various committee reports or maybe circulars which were issued in this regard. We will understand that. Then the legal framework, wherein we will discuss the uh, proper sections of the code, then regulations, all that we will discuss in this legal framework. Then what is the role of RP in case of AR appointment? So normally we should understand the appointment procedure also. So whether it is the duty of the RP to appoint any authorized representative, is he duty bound to do that? And how this whole process takes place, and whether he will be responsible for the work of the authorized representative, all that thing we will understand in this particular topic. Then what is the role of authorized representative? Uh, because we need to understand what is the duty, what is the responsibility, and what are the rights given to the authorized representative. Then how you can coordinate with authorized representative to have value maximization in your assignments. So coordination of AR with RP, how that can be done. And there will be some checklists also, which we will discuss. Then there will be some case laws where the role of AR is highlighted, how he should proceed in case of voting and all. Then we will understand the global scenario also, whether this concept is there in India only or in the other parts of the world. So let me tell you here that this concept is only in Indian IBC. So it's not there in other countries. So normally what we do in all our other legal regulations is that we see the global aspect and then we try to replicate those scenarios here. But here in this authorized representative concept, India is the first one to lead this. So we are the ones who will be the role model to set an example that if you have a great number of creditors, why not to have an authorized representative who will speak for them or who will take part in the meetings on their behalf. So that is something, a stand which is taken by the Indian IBC, and it is not there in other parts of the world. What are the various challenges which AR practically facing, and how to mitigate those challenges? We will discuss that as well. And what can be the best practice? How you can achieve your goal as a authorized representative? And obviously, we have discussed the professional opportunity. So before going further, let us first understand what was the scenario before IBC or pre AR framework. Let us talk about that. So there was lack of representation for the class creditors. So if there was a particular class of creditors, there was no representation uh, option available for them within the law. So just like in case of retail investors like home buyers or depositors, they had no formal representation in the COC. And obviously, because of lack of understanding of the laws, people were reluctant to attend the meetings. They did not take part in the meetings, and therefore the procedure used to go on for a long time. Only large financial creditors like banks or institutions had voting power and the excess. There was also inefficiency in real estate and NBFC cases. Home buyers had to individually file the claims. NCLT proceedings saw thousands of interventions, creating confusions and delay. There was also absence of unified voice, like each creditor acted independently. There was no collective voting mechanism, which had resulted in fragmented and conflicting participation. There was also unstructured communication. Resolution plans were not effectively communicated to the non-finance retail creditors. No legal obligation to communicate COC minutes or voting outcomes. So they were actually taken for granted. So therefore, there was an urgent need to have a proper system in place so that their voice could also be heard. So what is the actual background or the how this AR concept introduced? So we could understand, or we can now understand, that there was a need of collective representation. So with the inclusion of individual financial creditors such as home buyers, deposit holders, and retail bond holders after 2018 IBC amendment, the creditor pool became large and fragmented. These creditors lacked legal and procedural knowledge to participate meaningfully in the committee of the creditors. There was also a practical difficulty in direct participation. Just imagine a scenario of a COC with 500 home buyers individually managing notices, votes, meeting participations was logistically impractical, and administratively it was also burdensome. If you talk about any of the insolvency professional, it will be very cumbersome process for him or her to attend such cases. Then again, there was a risk of ineffective participation. Without centralized representation, such creditor classes could have been deprived of their voice, leading to unfair resolution plans or liquidation outcomes. It could also delay the CIRP process and complicate the decision making. Regarding the international practices, many jurisdictions like UK, Singapore allow for class action or representative participation in insolvency proceedings. IBC has adopted similar principle to align with the global best practices, but this kind of codified system which we have, this is not existing in the other countries. So we are the first ones to lead it. Now let's talk about the report of Insolvency Law Committee, which was issued in March 2018, which talked about this whole concept of authorized representative, and therefore the amendments were made in the law. So in the light of logistical and technical difficulties in ensuring participation by all the members in the COC, in large COCs basically, the committee deliberated on the need for a provision for representation of all the creditors, public depositors, or any other individual financial creditors. It's very important to note here that they clearly mentioned in the report that above a certain threshold, so this authorized representative will be appointed over and above a particular threshold only. So a number of persons was finalized here, that if in a particular class the number of people is this much, then only the authorized representative will be appointed. So in terms of number, this threshold will be given, and they will be represented by the authorized representative. Such authorized representative, now now they are talking about their rights and duties. So such authorized representatives may attend and vote on behalf of such financial creditors in the said meeting, express the concerns of the creditors being represented by it in the meeting, obtain clarity on the issues, and communicate any important concerns to the represented creditors. This shall further ensure the inter-se coordination among the creditors by having a common representative, as well as effective participation in the meetings of the COC. So participation by a single person representing many creditors is not only cost and time effective, but also it helps in the smooth functioning of the meeting. And therefore they are justifying that, yes, this is the time that we should incorporate this new concept of authorized representative in the law. However, suitable safeguards are necessary to ensure that the authorized representative protects the interest and acts in the best interest of the creditors that it represents. So again, there was a circular issued here, IBBI CIRP 015 in the year 2018, dated 13th July 2018. It is talking about the appointment of authorized representatives for class of creditors under section 21 6AB of the Insolvency and Bankruptcy Code. So we can directly check that out. Uh, just allow me 1 minute. We will go for that, but let us read these key takeaways from this circular. So wherever the approval of resolution plan under regulation 39(3) of the regulations is at least 15 days away, the resolution professional shall expeditiously obtain by electronic means the choice of the insolvency professional from the creditors in the class to act as the authorized representative of the class and proceed further in the manner as specified in regulation 16A of the regulation. So this para, this is this para which is given in the circular itself. So let us understand what was the concept or what was the context in mentioning this. So I'm just opening this circular. Just let me know if it is visible to all of you. Is the circular visible?
No, madam.
Is this circular is
No,
not
no,
visible? So I'll
no,
have to
no.
stop sharing the screen and then I'll have to share it. Just give me. Is it visible now?
Yes. Yes, yes, yes.
Oh, thank you so much for letting me know. See, this is the circular dated 13 July 2018. The subject is appointment of authorized representative for class of creditors under section 21(6)(a)(b) of the Insolvency and Bankruptcy Code 2016. So here we can see there are three paragraphs basically, and the first paragraph is highlighting each and every crucial point. So just let us focus on this. So it is talking about a particular section, section 21(6)(a)(b), which we will also discuss later in detail. So this is the particular section wherein they have inserted this provision of appointing authorized representative. So I'm just reading it out for you. Section 21(6)(a)(b) of the Insolvency and Bankruptcy Code 2016 read with regulation 16A. So these two are very important, section and the regulation. Regulation and 16A. So 16A1 of the Insolvency and Bankruptcy Board of India insolvency resolution process for corporate persons regulation 2016 regulation, that means CIRP regulations, regulation number 16A. It provides that where the corporate debtor has at least 10 financial creditors in a class. So here they have specified if in a particular class of creditors, if there are 10 financial creditors, the interim resolution professional shall offer a choice. So it is the duty of the interim resolution professional to offer a choice of 3 insolvency professionals. So again, authorized representative again should will be chosen by these financial creditors, the class of financial creditors. So option will be given to them. Out of 3, they have to appoint 1. So whosoever will get the highest vote will become the authorized representative. So this is how it all goes. But the choices will be given by the interim resolution professional. And by giving at the time of giving the choices, interim resolution professional has to make sure that the persons meet the eligibility criteria and everything. So 3 insolvency professional is what he will be giving them a choice to choose from, and the creditor in the class may indicate its choice of an insolvency professional from amongst the 3 to act as its authorized representative. So finally, how it is going? First of all, the IRP will at the time when he has got the claims from various these creditors, he will identify that if in a particular class of creditors there are 10, at least 10 financial creditors in a particular class. So if a particular class has at least 10 persons, then in that case it shall be his duty to give a choice of 3 insolvency professionals, out of which the creditors can appoint authorized representative from amongst them. So this is what it is mentioned in the next part of this para also. The insolvency professional who is the choice of the highest number of creditors in the class is appointed as the authorized representative of the creditors of the respective class. Next, it is telling you about the role and responsibility of this authorized representative. The authorized representative will collect voting instructions from the respective class of creditors, attend the meeting of the committee of creditors, and cast vote in respect of the said class in accordance with the instructions he receives from the creditors. So from each and every creditor, he will obtain these instructions. Suppose one person wants to vote in favor, the other person does not want to vote in favor, and so on. So he will get the instructions from them, and based on that only he can cast his vote. So that is very, very important here. Next, again, it is saying, so this particular section talks about the matters of procedure, how the whole process will be taken up. So it is very well made clear that in this circular itself that section 21(6)(a)(b) of the code read with regulation 16A, that is a complete code in itself for the authorized representative. So you don't have to look anywhere else regarding the procedure, everything is mentioned there. So it is necessary that an ongoing, if we are talking about an ongoing corporate insolvency resolution process, ongoing means at the time of 2018 when the circular was issued, it is necessary that an ongoing corporate insolvency resolution process where the creditors belonging to a class are otherwise not represented in the COC uses this simplified mechanism irrespective of the stage of the process they are in. So as soon as the circular was issued, every case which was ongoing at that time, if they were not having this authorized representative, they were supposed to have that at any point of time wherever the case was. So that is what it is mentioned here. And in line with that, this third para is also mentioned that it is accordingly clarified that wherever approval of resolution plan under section 39(3) of the regulation is at least 15 days away, the resolution professionals shall expeditiously obtain by electronic means the choice of the insolvency professional from the creditors in a class to act as the authorized representative of the class and proceed further. So as soon as this circular was issued, it was made compulsory on even on the going on cases. It was not that it will have to take place from a later date after this date. So on the it was applicable of, retrospectively, in fact. So whatever cases were going on, even in those cases, they had to take or appoint this authorized representative, and their choice was again important while approving the resolution plan. So this is what it is mentioned in this particular circular. So I'm stopping sharing this circular, and then let's get back to the main presentation. Okay, so this was the scenario when we were right now talking about the scenario uh, pre this authorized representative scenario we were talking about, and then when this clarification came or when the circular was issued and when the changes were made in the law, what happened thereafter. So now we will discuss about the scenario post implementation of this authorized representative rules and regulations. So there was a formal introduction of authorized representative role. AR was introduced under section 21(6)(a)(b) to represent creditor classes. He ensured one point of contact and voting on behalf of the class in the COC. Again, it led to efficient management of mass creditors. In real estate cases and NBFC CIRPs, AR now consolidating and representing thousands of creditors efficiently. Participation has streamlined through form CA. So this particular form is very important because here the choices are made by the respective creditors. Voting dashboards and WhatsApp IVR based outreach programs. Transparent and fair voting. Under section 25A, subsection 3A, AR cast vote strictly as per the majority creditor instruction. So again, it is clearly mentioned here that he has to vote as per the majority decision. Next, no room for subjective decision making. Therefore, it ensures fair and democratic representation. Then again, there is one more advantage, legal accountability and process discipline. AR must circulate COC agendas, minutes, and resolution plans to class creditors. Earlier, there was no responsibility on IRP or RP to circulate it to the masses. But here, with the advent of this authorized representative concept, it is now their duty to circulate these agendas of the meeting, minutes of the meeting, resolution plan, and everything. They have to communicate properly with the creditors. As we already also know that AR is paid as a CIRP cost, bringing process transparency and responsibility has come due to this whole concept. Now let us talk about the impact of AR introduction. So what was the scenario before and what is the scenario after? So earlier there was no COC representation for the retail creditors, and after the introduction of AR concept, structured voting via authorized representative for class of creditors was introduced. Next, before this concept, thousands of NCLT interventions were there, but now we can have a single point of contact per class. Then in the earlier scenario, there were no voting rights for the fragmented creditors, but now we can see that there are legal right. There is a legal right to vote via this authorized representative. Earlier, there was no uniformity in communication. However, in the post-AR scenario, we can see that AR communicates with COC notices, agendas, and votes. Then before AR scenario, there was no CIRP cost coverage for the communication. Now, whatever, see, again, it is, since it has been made as a duty of the AR to communicate properly, so whatever the cost of communication is there, or any kind of cost which is associated with his role, then that cost will be borne as CIRP expenses, and that shall be taken care accordingly. So now let us understand the role of authorized representatives with respect to the financial creditors. So broadly, we will be discussing this section 21 and regulation 16A. But we will also discuss a few parts of the other section wherein this concept has been, wherein this concept has affected. So if we talk about section 21, subsection 2, which is broadly about the formation of committee of creditors. Here it is mentioned that the committee of creditors shall comprise of all the financial creditors of the corporate debtor. Here it is clearly mentioned that in the proviso it is mentioned that provided that a financial creditor or the authorized representative of the financial creditor referred to in subsection 6 or subsection 6A or subsection 5 of section 24, if it is a related party of the corporate debtor, shall not have any right of representation. So in short, we can say that if this person is a related party, so even if the authorized representative is a related party, he will not have any right of representation, or he cannot become the part of the committee of the creditors. So what we can make out from this section or this subsection is this subsection clearly provides that AR would be a part of COC, which is being formed, but if there is a case of related party, they will not be allowed to become a part of COC. Then if we talk about section 21 6A, what does it say? Where a financial debt is there. So it is basically talking about the financial debt. So where a financial debt is there, subclause A, it says that is in the form of securities or deposits, and the terms of the financial debt provide for the appointment of a trustee or the agent to act as authorized representative for all the financial creditors. Such trustee or agent shall act on behalf of the financial creditors. So this concept was already there, that whenever you have a clear-cut regulation or a clear-cut law wherein trustee has to be appointed or some agent is appointed to act on your behalf, then that person will be working on behalf of those financial creditors in the name of authorized representative or in the name of trustee or agent, but his role will be just like authorized representative. What we are now trying to understand is this B point or the B clause. Let me read it again. Where a where a financial debt is owed to a class of creditors exceeding the number as may be specified. So the number specified is 10. We have already seen that. Other than the creditors covered in clause A. So clause A, that means where already it is a set rule that they will have a trustee or agent. We are not uh, paying respect. We are not talking about that. So besides all of them, if there is any other class of creditor existing, and there also we are having specified they are having more than 10 people, at least 10 in fact, if they are having at least 10 members, then in that case IRP shall make an application to the adjudicating authority along with the list of all the financial creditors containing the name of an insolvency professional other than the interim resolution professional. So he cannot himself act as a authorized representative. So that is very important, to act as their authorized representative who shall be appointed by the adjudicating authority prior to the first meeting of the COC. So this is very, very important, that it is the duty of the IRP to make an application to the adjudicating authority along with the list of all the financial creditors and also containing the name of the insolvency professional who will be who they are recommending to become the authorized representative. And this authorized representative should not obviously be the IRP himself. So that is a clear cut thing which is mentioned here. And now it is clearly said, or it is clearly mentioned here, that though the it is being recommended by IRP, 3 persons were recommended by IRP. The creditors have selected their choice. They have already made their choice and they have selected the best one from the list. Then the person who is having the highest vote, that is being shortlisted by IRP, he is making that he's mentioning that particular thing in the application when he's sending the application to adjudicating authority. And finally that person will be appointed by the adjudicating authority, and this appointment will be made prior to the first meeting of the COC. So finally the appointment is made by the adjudicating authority. The whole process will be done by IRP. That is what is clearly mentioned here. Again, there is one more clause here, clause C, where a financial debt is represented by a guardian, executor, or administrator, such person shall act as authorized representative on behalf of such financial creditors. So there could be various cases, there could be various scenarios wherein you can hear this word of authorized representative. But broadly, what we are dealing today in our session is regarding this B clause. So wherever we are talking about authorized representative, we are making this B clause in, we are talking about this B clause. So all these authorized representatives, whosoever are there, what they will do or how they will function, what is their role. So it is clearly mentioned here in this particular section itself that, and such authorized representative under clause A and B or clause C. So wherever he is appointed, in whichever clause he is being appointed, he will have the right to attend the meeting of the committee of creditors and vote on behalf of each financial creditor to the extent of his voting share. So this is his broad right and his responsibility or the duty. Let's move on further. So what is the final interpretation of this particular subsection? Section 21(6)(a)(b) provides that where the corporate debtor has at least 10 financial creditors in a class, the interim resolution professional shall offer a choice of 3 insolvency professionals, and a creditor in class may indicate its choice of an insolvency professional from amongst those 3 to act as its authorized representative. How they will indicate their choice, in which form they will do, so that is form CA, wherein they will specify their choice. So finally, how the appointment is made, the insolvency professional who is the choice of the highest number of the creditors in the class is appointed as the authorized representative of the creditors of the respective class. Next, we are talking about the duty. The authorized representative will collect the voting instructions from the respective class of creditors. He will attend the meetings of the COC and cast vote in respect of the said class. in accordance with the instructions he received from the creditors. So he cannot use his own mind. Rather, he has to work according to the instructions which are given by the class of creditors. Next, moving further in this section itself, section 21, 6b subsection is there, which talks about his remuneration. So the remuneration payable to the authorized representative under clause A and C, that means in case of trustee or agent, or in any other case where we talked about this C clause of section 6A, if any, shall be as per the terms of the financial debt or the relevant documentation. So whatever is decided as per their agreement or the document, they will have the remuneration that way. But if we talk about clause B, wherein for a particular class of creditors an authorized representative is appointed, then his remuneration shall be as specified. So we will have to check the regulation 16A for that. And this remuneration, whatever he will receive, will form part of the insolvency resolution process cost. So finally, the remuneration has been clearly elaborated upon in the regulations. There they have set the criteria on the basis of the number of creditors that AR is representing. So if it is 10 or more, the criteria is different. If it is 100 or more, the remuneration will be different. So that way, slab is there for the remuneration. If we talk about the voting, how they will vote, it is clearly mentioned in 21 subsection 7. The board may specify the manner of voting and the determining of the voting share in respect of the financial debts covered under subsection 6 and 6A. But the question here arises, what if some creditors don't respond at all? And whether in that case, can authorized representatives still vote? So regarding this voting, we will read in detail about the regulations. But before that, we should answer this question. What if some creditors don't respond? Can AR still vote? What is your answer for that? Any of the participants, you may write your answer in the chat box, or maybe you can unmute yourself and say it out. If the creditors do not respond,
they don't respond, it means they're not interested in that particular decision. So it is the negative. They're not confirming the decision, which means they're not for it.
So again, there are two concepts. Whether no has to be specified or clearly it has to be said no, or whether saying nothing means no also. How you should interpret that? Either you should have a clear yes, clear no, or whether there is any situation where no answer or no response is equal to no, or they are not in favor of the resolution.
Probably you add a clause when it is circulated to the creditor saying that you should answer if yes, or if no answer is received, you put a disclaimer clause, provided it is away. I mean, it is allowed in the code. I'm not sure whether code allows it, but you can, for the authorized representative to get away with it, not to have any problems in future with the NCLT or IBBI. So a disclaimer clause can be included. This is my opinion.
Right, sir. So, I mean, you can very well understand that this could be a confusion in the minds of authorized representative, how he should take up this situation. So, we should understand this, that if some creditors are not responding, AR can still vote as per section 25A, subsection 3A. Here it is clearly mentioned that AR must vote, but only on the basis of instructions received by him. Non-responses are treated as abstention. So decisions rest on the majority of those who have actually responded and not the total class size. So irrespective of the fact that whosoever has responded or whosoever has not responded, suppose there are 10 people in that particular class and only 8 have responded. So whatever the majority decision is there based on those 8 responses. he has to act accordingly. That is what is meant here. Next, section 24, subsection 3 of the code, it talks about the situation wherein the resolution professional shall give notice of each meeting of the committee of the creditors to the members of committee of creditors, including the authorized representative. So again, there is a responsibility, there is a duty of resolution professional to give the notice of each meeting of COC to the authorized representative. So that is very important. If you are a resolution professional in any of the assignments, it is your duty to give this notice of meeting of COC to this authorized representative also. So whether at any in whichever way he is appointed as an authorized representative, in all the cases he will be given this notice of attending the meeting. Again, here clause C says that operational creditors or their representatives, if the amount of their aggregate dues is not less than 10% of the debt, so notice will be given to the financial creditors. Obviously, we know that because they are forming the committee. Then authorized representative, if any, an authorized representative of the financial creditors. That is what is mentioned in the first part, A part that we have seen. Now this C clause, it is clearly saying that even in the case of operational creditors, they can also have their representatives. And clearly it is mentioned here that if they are representing 10% of the debt, minimum 10% of the debt, then they can have their representative also. So not only in the case of financial creditors, you will have the authorized representative, but here maybe in certain scenarios, if operational creditors are holding minimum 10%, then also you can have the this kind of representation from operational creditors also. So, but the question here arises whether they will have the voting right or not. So even if they are present in the meeting, because it is the duty of the resolution professional to invite them for the meeting. But whether voting right will be given to them or not, that is again a question. So regarding that, there is a clarification. Since the authorized representative represents the creditors who are a part of the COC, a notice of the meeting would need to be issued to them as well. That is something which we all understand. But we have to take into account that the representative of the operational creditors who are attending the meeting of the creditors, they can attend the meeting, but they will not have any right to vote in such meetings. So as per the duty of the resolution professional, he has to give notice to all these people. But again, if a person is representing the operational creditors, he can attend the meeting, but he will not have any right to vote. That distinction is something which we need to understand. I hope this is clear. Moving further to section 25, capital A, which talks about the rights and duties. Rights and duties of the authorized representative of the financial creditors. In subsection 1, it is mentioned that the authorized representative, in whatever way he is being appointed as an authorized representative. See, again and again, these subsections are coming in. Subsection 6 or 6A or subsection 5 or of 24. So all these are the various provisions which are given in the law in which this authorized representative can be appointed. So 6A is broadly the authorized representative we have discussed so far. They shall have a right to participate and vote in the meeting. So the first and foremost duty of the authorized representative is to participate and vote in the meeting of the committee of creditors on behalf of the financial creditors he is representing. Then again, it is clearly mentioned in the subsection 1 itself that they will be voting and participating as per the instructions given. So in accordance with the prior voting instructions of such creditors, and these instructions he might have received through physical means or by electronic means. So by any of the modes, this representative can have the instructions where to vote, on how to vote, what will be the final call. from the creditors. Subsection 2. It shall be the duty of the authorized representative to circulate the agenda and the minutes of the meeting of the committee of creditors to the financial creditor he represents. So the first duty is to participate and vote in the meeting as per the instructions. Second duty will be to circulate the agenda. So this will be done prior to attending the meeting. So before he attends the meeting, he has to circulate the agenda of the meeting. He has to obtain the voting instruction. Then he has to participate in the meeting, vote in the meeting, and then whatever was concluded in the meeting, those minutes he has to share to the financial creditors or the class of financial creditors he is representing. Subsection 3 says that authorized representatives shall not act against the interest of the financial creditor he represents and shall always act in accordance with their prior instructions. So again, it is a kind of duty that he will always abide by the instructions and he will never act against the interest of the financial creditors. There is a proviso also here, provided that if the authorized representative represents several financial creditors, then he shall cast his vote in respect of each financial creditor in accordance with the instructions received from each financial creditor to the extent of his voting share. So whatever instruction he has received from each financial creditor, he will vote for each of the financial creditors. So earlier, we saw that there were 3 clauses. So let me get back to that slide firstly. These 3, A, B, and C. So for A and C, it is clearly mentioned that how many number of financial creditors are there, that many instructions you will have, and accordingly, that many times you have to vote. But in case of this B clause, we will see that majority voting voting will be based on the majority decision. So this is a clear-cut distinction which we have to understand in case of voting strategy. So that is the duty which is given here in 25A. It is mentioned here also. Provided further that if any financial creditor does not give any prior instruction, though physical or electronic means, the authorized representatives shall abstain from voting on behalf of such creditor. So just now, one of the participants mentioned that we can have a disclaimer saying that no voting or no instructions would mean we will count it as no. But the law clearly has mentioned it in one of the provisos that you should try to abstain from voting on behalf of such creditor who has not given any instruction. So if there is no instruction, that simply means you don't have to count that at all. You don't have to vote for that particular person also. Next, section 25 capital A, subsection 3A, it again furthers tell you the rights and duties. So notwithstanding subsection 3, which we have just discussed, so the voting right, let me get back to this slide. Here they were talking about the voting rights of the other authorized representatives. But in case of clause B, how that shall be perceived, that is mentioned here. The authorized representative under subsection 6A of 21 shall cast his vote on behalf of all the financial creditors he represents in accordance with the decision taken by vote of more than 50% of the voting share of the financial creditors he represents who have casted their vote. So take only account those members or those financial creditors who have casted their vote, and out of them you choose more than 50%. So if there is a total of 10 persons in a particular class, then only 8 have responded or 8 have casted their vote. Then you bifurcate votes in favor, votes against, and if you have more votes in favors, that means if you have more than 50% of votes in favor, finally the authorized representative will cast his vote in favor in the meeting. So that is how he will cast his vote. So more than 51% is the criteria, or more than 50% in fact is the criteria, provided that for a vote to be casted in respect of an application under section 12A. Now, if there is a resolution to be passed for this withdrawal of application, section 12A, So in that particular scenario, the authorized representative shall cast his vote in accordance with the provisions of subsection 3. That means for each of the individual creditor, he will have to obtain the instruction. He cannot vote just like majority voting. He will have to individually vote for each and every person. So that is what is clearly mentioned here, that individually he will have to vote if there is any application for this 12A. I think this voting part is making sense, that for whom he has to take 50% criteria or 51% criteria, and for the others he has to take the individual voting. Moving further, section 25 capital A subsection 4, it says the same section is for rights and duties, and we are just discussing the different subsections under it. The authorized representative shall file with the committee of creditors any instruction received. So again, these instructions will not stay with the authorized representative only. He will have to give it to the committee of creditors also. He will have to hand it over to them. So he has to file with the committee of creditors any instructions received by way of physical or electronic means, whatever he has received from the financial creditor, for voting in accordance therewith, so that they can also check whether he has voted correctly or not. So this is what he has to finally submit it to the committee of creditors to ensure that appropriate voting instructions of the financial creditor he represents is correctly recorded. So recording will be done by the IRP or RP as the case may be. So ultimately, authorized representative will file these instructions to the committee of creditors. Basically, he will hand over the instructions to the IRP or RP. They will take that in their record, whatever instructions were received by this authorized representative for voting purpose. The explanation here is saying is talking about the electronic means. What do you mean by electronic means? And that is discussed in regulations. What do you mean by electronic means? So now let us understand the regulations part. In the code, we have these sections which we discussed here. They are related to the this AR topic. We have covered all the sections there in the code. Now we are talking about the regulations, CIRP regulations we are basically talking about. So regulation 2, wherein the definition is given for this class of creditors. What do you mean by class of creditors? So subregulation AA here talks about this class of creditor. It means a class with at least 10 financial creditors under clause B of subsection 6A of section 21. And the expression creditors in class shall be construed accordingly. So again, class of creditors simply means wherever similar kind of creditors are there, they will be grouped into one class. And if minimum they are 10 people in that particular category or in that particular class, they will be now known as class of creditor, one class of creditor. And they may be different classes of creditor. And different authorized representatives can be appointed for different classes of creditors. Now talking about regulation 4A, which is about the choice of authorized representative. So how this choice will be made, how that will be decided. So the sub-regulation 1, it says that on examination of the books of accounts and other relevant records of the corporate debtor, if the IRP is ascertaining that there exists some class of creditor, then for that purpose, he will ask for the representation. So he will identify 3 insolvency professionals who are, so basically it is telling you the criteria, eligibility criteria. So eligibility criteria, who can become this authorized representative is given in regulation 4A. So who can become an authorized representative? First, it is clearly mentioned that insolvency resolution professional, he obviously cannot become the AR. Neither his relatives or related party can become the AR here. So first and foremost thing is the insolvency professional who are his relatives or related parties cannot become the AR. Then second, they are having addresses or as registered with the board in the state or union territory, as the case may be, which has the highest number of the creditors in the class as per their addresses in the records of the corporate debtor. So suppose maximum creditors are living in Pune or Pune maybe. So in there, whosoever insolvency professional's address is of that location, who's belonging to Pune maybe, he can be taken up as one of the choices for being appointed as the authorized representative. So here we are understanding how IRP is making a choice of three people, how he takes names of three, how he identifies three insolvency professionals. So first, he will clearly chalk out those who are his relatives or related parties. Second, he will look into that person whose address is similar to the address of maximum or the highest number of creditors in that particular class, so that the communication will be very smooth between him and the creditors, because they are in the same location. So that is mentioned here. There is a proviso also here, provided that where such state or union territory does not have adequate number of insolvency professionals. So just for example, if Pune does not have any insolvency professional, then the nearby location, wherever insolvency professional is there, he will be identified as one of the choices. Next criteria is he is eligible to be insolvency professional under regulation 3. So he should be a registered insolvency professional. He should hold AFA also. So that is again one of the criteria. And he is also willing to act as the authorized representative of creditors in the class. So consent is also to be obtained beforehand, before making this choice. So this is the duty of the IRP, to select those people who are actually willing to act also. So his consent is to be obtained by the IRP before mentioning their names in the final document. The interim resolution professional shall obtain the consent of each insolvency professional identified under subregulation 2 to act as the authorized representative of the creditors in class in the form AB of the schedule. So he will mention his name, their names there. So this is the eligibility criteria we have. Regulation 4A talks about the eligibility criteria, and also regulation 16A furthers that criteria. So the basic eligibility criteria is that he must be a registered insolvency professional. He should have a valid authorization for assignments. Then he should not represent any other stakeholder in the same IRP. Disqualification criteria: he should not be a related party of the corporate debtor, has any conflict of interest, personal or professional. He's already acting as IRP, RP or liquidator or COC advisor in the same case, then he should also not be taken up for this role. Selection criteria: he selected based on the highest number of consents received from the creditors in the class through form CA. So through this form, the creditors will indicate their choice, and the person with maximum votes or maximum consents will finally be selected as the authorized representative. Final appointment is confirmed by NCLT on IRP's recommendation. So finally, he is appointed by the NCLT, and the recommendation is obviously done by IRP. So in the public announcement also, the names will be mentioned. So here it is clearly mentioned that in regulation 6(2)(BB), it is mentioned that offer a choice of 3 insolvency professionals is identified under regulation 4A to act as the authorized representative of the creditors in each class. So this will be clearly mentioned in the public announcement also. AR is appointed out of 3 options given to the class of creditors to pick from. So in the public announcement, the choice of 3 insolvency professionals will be clearly mentioned. Regulation 8A, subregulation 3, it talks about the situation where a creditor in a class may indicate its choice. So it is the duty of the IRP to mention it in the public announcement, and then it is the right of the creditor to indicate his or her choice of the insolvency professional from amongst the 3 choices given to him by the IRP or in the public announcement itself, and he can choose any one of those three to act as its authorized representative, and this choice he will indicate in the form CA. Class of creditors will pick one person out of the three options given to them after obtaining consent from all for being appointed as an authorized representative. Moving further, Regulation 9(2), it is about the claims by workmen and employees. Here also a term of authorized representative is used, so therefore we are discussing this. Where there are dues to numerous workmen or employees of the corporate debtor, an authorized representative may submit one claim with proof for such dues on their behalf in Form E of the schedule. This we all know that instead of giving so many applications, we can directly have that. Just let me go back to the slide. Yeah. It is one of the duties of the AR to collect the claims and apply with a consolidated claim form. Next is Regulation 13(2)(b). It talks about the verification of the claims. The list of creditors shall be made available for inspection. So whatever the list is finally prepared, that shall be available for the inspection not only by the members, partners, directors, or guarantors, but even to the authorized representative. So this is again a right which is given to the authorized representative, that they can verify or they can inspect this list of creditors. Regulation 16(b). It talks about the committee with only creditors in a class. So let us see what is the situation given here, where the corporate debtor has only creditors in a class and no other financial creditor eligible to join the committee. The committee shall consist of only the authorized representative. So this we can very well understand. Regulation 16(c), appointment of facilitators. This is again a new term, facilitator. Who is a facilitator? Where the number of creditors in a class exceeds 1,000, the committee may direct the IRP to appoint a facilitator. So over and above this authorized representative, there is one more person who is known as facilitator. The threshold here mentioned is 1,000. So if a class consists of more than 1,000 persons, then they may have a facilitator also. Regulation 16(a). This is the main regulation, and this I think we can take it up from the regulations.
Madam,
Yes,
sorry
sir.
to interrupt. The
Yes, sir.
16C you're talking about
16C.
appointment of facilitators.
Yes, sir.
When is this amendment thing?
So
When is it come into?
I'll just take you to the regulations directly, and there we can see that. Just let
Okay.
me take up the next slide, and then we will switch on to the main regulations, CIRP regulations only. We will read directly from there. Regulations, I've just summarized this regulation 16(a). What is the basic crux of this whole regulation? So sub-regulation 1 and 2, they talk about that IRP will identify the classes of the creditors based on the claim submission. So first of all, it is the duty of the IRP to identify the classes. Then he will receive the nominations from IP in the form AB and preferences from the creditors in form CA. Then regulation 16(a), sub-regulation 3, it talks about that the IP with the highest number of creditors consent is proposed as authorized representative to NCLT. So the person who is having highest vote will be finally asked, the application will be shared with the NCLT to finally appoint him. That will be his duty. Then sub-regulation 4 talks about that the authorized representative is deemed to be a COC member from the date of the appointment. So as soon as NCLT confirms his appointment, from that date onwards, he will be deemed to be appointed. Next, sub-regulation 5, it talks about that AR must circulate minutes of COC meetings and seek voting instructions promptly. Sub-regulation 6 says that AR is entitled to a fees which is payable proportionately from the creditor's class he represents, and the fee schedule is mentioned in this regulation itself. So in short, if we talk about this regulation 16A. Here, the process of appointment and the functions of an authorized representatives are given under this regulation. So it specifies that AR needs to be in consultation with the class of the creditors that he represents. He has to act within their instructions only. So if an AR is appointed for a class, then the creditors in that class will not be allowed to attend the meeting of the COC. This is very, very important. So if an authorized representative is appointed, only he can attend the meeting, the others cannot attend the meeting. If you compare it with the Companies Act scenario wherein a proxy is appointed, and suppose that proxy and the main member who has appointed that proxy, if both of them go to the meeting, then the member will be allowed to attend the meeting and not the proxy. But here the case is the authorized representative will be allowed to attend the meeting and not the other members of the class of the creditors. So this is the basic difference. Now let us check these regulations. I'll have to stop sharing this screen and then I'll have to share again. Just allow me 1 minute. Just let me know if my screen is visible. I'm going to regulation 16A directly. Is my screen visible?
Yes, madam.
Okay. So regulation 16A. See, the first sub-regulation here, it is talking about the thing which we have discussed in nutshell there. The interim resolution professional shall select the insolvency professional who is of the highest choice. I think I can skip this. Form number is mentioned, Form CA. So I'll read this proviso basically. Provided that the choice of an insolvency professional to act as the authorized representative by the financial creditor in a class in Form CA shall not be considered if Form CA is received after the time stipulated in the public announcement. So within the time, if you receive this Form CA, only that will be considered and not otherwise. So thereby they are just simplifying the procedure for the IRP also to make the decision. Next, sub-regulation 2. The interim resolution professional shall apply to the adjudicating authority for the appointment of authorized representative selected under sub-regulation 1 within 2 days of the verification of the claims received under sub-regulation 1. So the time is also mentioned here within what time he has to apply to the adjudicating authority. Then again, a proviso is there, provided that till the application for the appointment of the authorized representative for a class of creditors is under consideration before the adjudicating authority, the insolvency professional selected under sub-regulation 1 shall act as an interim representative for such class of creditors and shall be entitled to attend the meetings of the committee and shall have such rights and duties as that of the authorized representative. So even if he is not appointed as such, interim role is given to him. So that is also mentioned here. Any delay in the appointment of the authorized representative for any class of creditor shall not affect the validity of any decision taken by the committee. That is clearly mentioned here so that we do not have any doubt about the resolutions which take place at that time. Sub-regulation 3A. The financial creditors in the class representing not less than 10% voting share may seek replacement of the authorized representative. So now we are discussing a scenario where this authorized representative can be replaced. So whether replacement is possible, yes, the replacement is possible, but again, there is a threshold who can apply for this replacement. It should not be a single person, but it is mentioned that the minimum 10%, so not less than 10% of the financial creditors in class. So this again percentage will be on the basis of voting share they have. So on the basis of that, they can file an application and then they can remove this person and they can replace the other person. So I'm just reading it for the benefit of all. The financial creditors in the class representing not less than 10% voting share may seek replacement of the authorized representative with an insolvency professional of their choice by making a request to the interim resolution professional or resolution professional, who shall circulate such request to the creditors in that class and announce a voting window open for at least 24 hours. So, this kind of application or this kind of request can be made by minimum 10% voting share of the particular class of creditors, and then again voting will take place who can be the next authorized representative. So that way it happens. Next, 3B, subregulation 3B, subject to clauses A and B of subregulation 2 of regulation 4A, that is the eligibility criteria which we had discussed earlier. The interim resolution professional or the resolution professional, as the case may be, shall offer choice of at least 3 resolution insolvency professionals to the. So this, I think it's okay. He will give the choice of 3 persons. So again, 3 persons choices will be given to choose from. That is meant here. So let me just read it again. Subject to clauses A and B of subregulation 2 of regulation 4A, the interim resolution professional or resolution professional, as the case may be, shall offer choice of at least 3 insolvency professionals to the financial creditors in the class, including such insolvency professionals proposed under subregulation 3A, along with the existing authorized representative. So if there is any case of replacement, then again choice of 3 insolvency resolution professionals should be there along with the existing authorized representative. So this is what is meant here. Next, subregulation 3C. The resolution professional shall apply to the adjudicating authority for the appointment of the authorized representative who receives the highest percentage. So finally, if the replacement takes place, again the finalization will be done by the adjudicating authority. It is not done. It will not be finalized by just the voting by the creditors. It will again be finalized by the adjudicating authority only. So that is mentioned here. Subregulation 4, it says that the interim resolution professional shall provide the list of creditors in each class to the respective authorized representative appointed by the adjudicating authority. So obviously, the adjudicating authority should be given the list of the creditors with whom he will have to communicate. So that list will be provided by the interim resolution professional. So that is the duty of the interim resolution professional, and at the same time, it is the right of the authorized representative to have this list of creditors. Next, the interim resolution professional or the resolution professional, as the case may be, shall provide an updated list of creditors in each class to the respective authorized representative as and when the list is updated. So again, if any updation takes place, obviously that is also to be communicated to the authorized representative. Clarification is given here. The authorized representative shall have no role in receipt or verification of the claims of the creditors of the class he represents. So there was a case also with respect to this, whether this authorized representative has any role of verification of the claims. So he has no role in the verification of the claims. So his role is just very much restricted. He will just have the details from the interim resolution professional. He will have the instructions from the class of creditors, and then he will just attend the meeting and vote. So that is his only role. He has no role to verify the list of or the claim of the creditors. Next, the interim resolution professional or the resolution professional, as the case may be, shall provide electronic means of communication between the authorized representative and the creditors in the class. So it is the duty made for interim resolution professional or the RP. They will provide the electronic means of communication between authorized representative and the creditors of that particular class. Then the voting share of the creditor in a class shall be in proportion to the financial debt, which includes an interest at the rate of 8% per annum unless a different rate has been agreed to between the parties. Okay, that is okay. Then subregulation 8, it talks about the fees. Let us just directly see the fee structure. We all are interested in that. The authorized representative of creditors in a class shall be entitled to receive fees for every meeting. It is mentioned for every meeting attended by him. So for every COC meeting which he attends, he will have this amount as fees. So if the number of creditors in that particular class is 10 to 100, then the fees per meeting is 30,000. If it is till 100 to 1,000, then in that case it is 40,000 fees per meeting. Then if the number of creditors is more than 1,000, then it is 50,000. So these have just doubled. Earlier in the original provision, it was half the rates which are given now. So these have been amended. The remuneration has been amended. Again, so this we should know that two kinds of remuneration will be given to the authorized representative. One is to attend the meeting of COC. So this just now which we have discussed is with respect to attending the meeting of COC. And now if he at any time conducts the meeting of the class of the creditors only, so it is with him, he is at conducting a class of creditors. So in that case also he will receive a fees. So the authorized representative shall be entitled to receive fees for every meeting of the class of the creditors convened by him in the following manner. So if the class of if the number of creditors is 10 to 100, he will receive 10,000 for every meeting he convenes in any meeting with the creditors or with the class of creditors. He will receive this fees. So two kinds of fees he will receive. So 10, 12, and 15, that is the criteria, that is the slab which is mentioned here. The payment of the fees to the authorized representative shall form part of the IRP cost. We understand that in respect of two meetings with the creditors, he represents corresponding to a meeting of the committee of creditors. So there is a limit which is put here. The fees for any additional meeting beyond two meetings corresponding to a meeting of the committee of creditors shall be part of the insolvency resolution process cost subject to the approval of the committee. So for the two meetings, there is no need to take the approval, but if he conducts more than two meetings, then obviously that will have to be approved by the COC. Sub-regulation 9. It says that the authorized representative shall circulate the agenda to the creditors in a class and may seek their preliminary views on any item in the agenda to enable him to effectively participate in the meeting of the committee. So when we are saying that he has the right to participate in the meeting, he can take part in the discussions also. He can put forth the concerns of the creditors, and therefore it is mentioned that he can seek the preliminary views of the creditors. Okay. Provided that the creditors shall have a time window of at least 12 hours to submit their preliminary views, and the said window opens at least 24 hours after the authorized representative seeks the preliminary views, provided further that such preliminary views shall not be considered as voting instructions by the creditors. So these are just the views and not the instructions. So there is a distinction made here in this particular proviso, and the time limit is mentioned for what time you have to keep this window open to seek the views and all. Okay, sub-regulation 10. It details about the duties of the authorized representative. So what is the duty of authorized representative? Broadly, it is given in this sub-regulation 10. The first duty is to assess the creditors in a class he represents in understanding the discussion and considerations of the committee meetings and facilitate informed decision making. Just to tell this again, that this authorized representative is a professional person. He himself is an insolvency professional, so he understands the law very well, and it is his duty to make the class of creditors understand the legalities, the matters which are being taken up in the meetings. So he has to make them understand so that they can make an informed decision. So this is his first duty. Second is to review the contents of the minutes prepared by the resolution professional and provide his comments to the resolution professional, if any. Third, to help the creditors in a class he represents during the consultations made by the resolution professional to prepare a strategy for marketing of the assets of the corporate debtor in terms of sub-regulation 1 of regulation 36. So again, you can see here that he can even assist or he can even provide his consultancy to prepare a strategy of marketing of the assets also. So that way also he can help out. Next, work in collaboration with the creditors in class he represents to enhance the marketability of the assets of the corporate debtors. So that is also his duty. See, these are all what we are reading, the duties of the authorized representative. To assess, next E point, assist the creditors in the class he represents in evaluating the resolution plan submitted by the resolution applicant. So again, everything he has to make them understand. So for any of the resolution plans which are received, he will evaluate from his side and he will communicate and make the class of creditors understand that particular resolution plan. Next, ensure that the creditors in a class he represents have access to any information or document required to form an opinion on issues discussed in the committee meetings. So he can even demand, or firstly, he has the access to any kind of information and he can also obtain those information from the resolution professional or IRP, whichever is necessary to form an opinion. Form an opinion for the matters to be discussed in the committee meetings. Next, update regularly the creditors in a class he represents on the progress of the corporate insolvency resolution process. So there has to be a regular interaction. That is what is meant here. Next, to make suggestions for modifications of the resolution plan as may be required by the creditors. Then next is record the proceedings and prepare the minutes of the meetings with the creditors in a class he represents. So there are two kinds of minutes which we can identify here. Is one is the committee of creditors COC meeting minutes, which IRP or RP will give to him and he has to circulate it to the class of creditors. Next, we are talking about the meetings which they are conducting within themselves. So if there is any class of creditors meeting is happening, in that case, it is the duty of the authorized representative to prepare minutes of that particular meeting and then again circulate it. The next is we are here on I point, I guess. Make suggestion for the modification we have seen. I, record the proceedings and prepare the minutes we have seen. Then J, act as the representative for the creditors in a class he represents in representation before the adjudicating authority, NCLT, and any other regulatory authority. So he will be their representative at all the forums. That is again his duty. That is clearly mentioned here. We will just finish off with this and then we will take a break. Subregulation 11, it says that the provisions regarding minutes of the meeting in this regulation shall apply mutatis mundis. So whatever provisions are there for preparation of the minutes, the same will apply here. Subregulation 12, it says that the creditors in a class may propose any additional responsibility also upon the authorized representative in relation to the representation of their interest in the committee. So broadly, whatever is mentioned here, that is the duty. And besides that, if the creditors feel like they can also add on the responsibilities on these authorized representatives. Now coming to that 16C, sir, this has taken place. The amendment has taken place in, just see this. This has been inserted by notification number so and so on 3rd February 2025. So it is a recent amendment regarding this facilitators. Appointment of facilitators. So this is a new regulation which is inserted here. Then with this, role and responsibility of facilitator is also mentioned. 16C, 16D. Both of this you have to read to understand the broad criteria for appointment of facilitator. And this facilitator has to see this point, if you can just read it here. The responsibility of the facilitator is will include facilitating communication between the authorized representative and the creditors of the subclass. So that their communication goes on well, there is a separate monitoring person which is known as facilitator. And Therefore, his responsibilities are also very important. So I'm just stopping the screen share here. We can take a 10 minutes break and then we will resume with the case laws which are there and some question and answers based on this whole concept of authorized representative. So we will be back at 4:25. So hello, let's resume the session. Let me share the presentation again. I hope my screen is visible. So till now we have discussed about the roles and responsibility of the authorized representative, the legal provisions with respect to uh, this person. There are a few more regulations which talk about authorized representative. So one of them is this regulation 21(2), which is about the contents of the notice for the meeting. So let's read what it says. The notice of the meeting shall provide that the participant may attend and vote in meeting either in person or through an authorized representative. So it is important to mention in the notice itself. This is one of the major point which is to be there in the notice, that meeting can be attended either in person or through authorized representative, provided that such participant shall inform the resolution professional in advance of the meeting of the identity of the authorized representative who will attend and vote at the meeting on its behalf. So it is just like the case of proxy in companies, that we have seen that if the proxy is attending the meeting, his details are also to be disclosed beforehand. So similarly, here also, whosoever is sending the authorized representative, they have to mention that this person will attend on our behalf. So AR is granted the right to attend a COC meeting if he is finally appointed. Next is regulation 25(5). It is about the voting by the committee. The resolution professional shall circulate the minutes of the meeting by electronic means to all the members of the committee and the authorized representative, if any, within 48 hours of the conclusion of the meeting. So it is the duty of the resolution professional to circulate the minutes of the meeting. Electronically, it is clearly mentioned that he has to circulate electronically only. To whom he has to circulate? He has to circulate to all the members of the committee and to the authorized representative as well. And the time limit is mentioned within the 48 hours of the conclusion of the meeting. He has to do that. Then in sub regulation 6, it says that now it is the duty of the authorized representative to circulate these minutes of the meeting which he has received, just above which he has received. He has to circulate it to the creditors in a class and announce the voting window at least 24 hours before the voting window opens for the voting instructions, and keep the voting window open for at least 12 hours. So before the actual voting starts, before that 24 hours, he has to make the window open to receive the instructions from the class of the creditors, and that will go on for 12 hours. So that is the time limit which is clearly mentioned, which any authorized representative has to follow. So it is also the duty of the authorized representative to circulate the minutes of the meeting to its class of creditors and inform them of the voting requirements and the windows of the voting. Next, regulation 25A, voting by the authorized representative. The authorized representative shall cast his vote in respect of each financial creditor or on behalf of all the financial creditors he represents in accordance with the provisions of subsection 3 or subsection 3A. So this we already understand that how he has to cast his vote. He has to vote on majority or individually, as the case may be. So AR will take the votes cast by the creditors in its class and present them to the IP for decision making. Regulation 31, CIRP cost. This we already have discussed. Still, insolvency resolution process cost, which is defined under section 5, subsection 13, clause E, it shall mean any fees payable to the authorized representative under sub-regulation 8 of regulation 16A. So this will form part of the CIRP cost. It is clearly mentioned in this definition itself. And this clause AB, it says that any out-of-pocket expenses of the authorized representative for discharge of his functions under Section 25A, that will also form part of the CIRP cost. So any fees which is payable as well as any out-of-pocket expenses will be given to authorized representatives on priority basis in the waterfall mechanism. The fee and out-of-pocket expenses of the AR are recovered under resolution process cost and will thus need to be ratified by the COC. So ratification is required for this purpose. This we all know. So let us move further. Now let us talk about various forms which are used in the case of appointment or any other proceedings of this authorized representative. So one is Form AB, which is used to which is used as a consent to act as an authorized representative. So this will be shared by the insolvency professional who wants to become an authorized representative. So it's a consent from insolvency professional that he is ready or he is willing to be appointed as an authorized representative. So his consent will be given in Form AB. Then Form CA, this we had talked about earlier also. This is used for submitting claims by financial creditors in a class. So creditors in a class will submit their claims in this form, and in this form itself they will mention whom they want to be appointed as a authorized representative. So out of these three insolvency professionals, he will choose or he will write the name of one of them in this form itself. Next is Form E. Form E is used to prove claims of workmen and employees by the authorized representative. So it's a consolidated claim. We all know that. Next is this Form CP1. This is prepared by IRP, which contains the details of the authorized representative also. So when you are detailing the process, progress of the this CIRP, then IRP or RP has to submit various forms to the adjudicating authority. So this CP1 form, it also contains the details of this authorized representative. Then Form A, that is the public announcement. Here, a name of 3 IPs will be mentioned to choose from. So these are the various forms which we should know about. Then there is one more clarification circular which was issued on 6 December 2019 regarding the voting part. So voting on behalf of creditors in a class in the CIRP of JP Infratech Limited. For this purpose, this clarification was issued. We will directly read it from there. Let us first know the summary of this circular. The resolution professional or the authorized representative is duty bound to conduct the process, including voting, strictly in compliance with the code, regulations, and order dated 6 November 2019 of the Honorable Supreme Court in the matter of Jay Prakash Associates Limited and others versus IDBI Bank Limited and another, and to suitably inform the creditors in such class about the timing and the manner of voting by them on the resolutions or the resolution plan to obviate any confusion. So besides following code, rules, regulations, also this judgment has to be followed regarding the voting pattern or the manner of voting. So this has also to be communicated to the class of creditors. So that is what is mentioned here in the circular. So I'll have to again stop sharing the screen of this presentation and then I will share this circular. Just a minute. I hope my screen is visible. Okay, so the subject here is voting on behalf of creditors in class of CIRP of JP Infratech Limited. So several mails were received by the board from some financial creditors in a class, namely home buyers, expressing confusion about the manner of voting in the context of resolution plan in the corporate insolvency resolution process of JP Infratech Limited. It appears that there is internal voting, pre-polling on certain matters which are not in the agenda before the committee of the creditors. This prima facie does not appear to be in consonance with the Insolvency and Bankruptcy Code 2016 read with the regulations and has the potential to vitiate the voting process. So if I move it further, if I scroll it further, Regulation 16A9 of the regulation mandates the authorized representative to circulate the agenda to the creditors in a class and announce the voting window at least 24 hours before the window opens for the voting instructions and keep the voting window open for at least uh, 12 hours. This we have already read in the regulation. That is what is being mentioned here as well. Further, Regulation 25(6) of the regulation requires the authorized representative to circulate the minutes of the meeting received under Sub-Regulation 5 of Regulation 25 to the creditors in a class and announce the voting window at least 24 hours before the window opens for voting instruction and keep the voting window open for at least 12 hours. Thus, the regulations enable a creditor in a class to give voting instruction to the authorized representative at two stages. First, after circulation of the agenda, and then after circulation of the minutes. So there are two windows for the voting. In view of the above, it is hereby clarified that resolution professional or authorized representative is duty bound to conduct the process, including voting, strictly in compliance with the code, regulations, and the order dated 6th November 2019 in this particular matter of Jayaprakash Associates Limited, and to suitably inform the creditors in such class about the timing and manner of the voting by them on the resolutions or the resolution plan to obviate any kind of confusion. So this was finally clarified by this circular regarding the voting instructions and all. I know a lot of theory is going on, but once we are thorough with the theory part, then we can take up some case studies also, so that you can easily understand the matters which were raised before NCLT or NCLAT. So we have till now discussed about how this AR concept has been introduced, how this AR will be appointed, what is his role and duty. Everything we have discussed. We have read about various sections. We have discussed about the rules and we have discussed about the regulations also. So now let us finally and quickly understand what are the benefits of AR to various stakeholders. So is it beneficial to appoint authorized representative or it is not? So let us first discuss about the financial creditors for a particular class, whether it is beneficial to appoint authorized representative. Yes, of course, because there is a simplified communication. There is one point of contact, they know. Then there is empowered participation. They have a clear channel to convey the votes, their opinions, their concerns, etc. Also, they have access to the updates, which was not existing earlier. So as we know, it is the duty of authorized representative to keep them updated. So timely information will help them to take proper decision. So they also have the access to updates. Now, if we talk about the resolution professional, whether it is beneficial for them to have authorized representative, yes, for them also it is beneficial. There is a streamlined process. If you engage with one authorized representative rather than hundreds of individuals, your time will be saved, your energy will be saved. Next, there is reduced administrative burden. Then there is better coordination for COC meetings and votings. Then if we talk about adjudicating authority, whether it is beneficial to have these authorized representatives or not. Yes, it is again beneficial for them because there is efficient hearing and less procedural confusion. It promotes effective representation and balance in creditors' rights. If we talk about the corporate debtor and other stakeholders, whether it is beneficial to have authorized representative or not. Of course, yes, again for them also, because it leads to faster resolution process. It reduces the litigation risk. So ultimately, what is the benefit of appointing authorized representative? If I summarize, it will be like this. First is it helps them to create effective representation of fragmented creditors. So it enables creditors like home buyers or deposit holders who are often in thousands of numbers. They can have a proper point of contact. They can raise their concerns through that particular person. So it ensures their participation without any logistical chaos. Next is it uh, provides a benefit of faster and more efficient COC decision making. Then it has a statutory backing also. We know that there are various judicial decisions also for appointing authorized representative, and it is beneficial for everyone. Then it reduces litigation also by disgruntled individuals. It prevents every single dissenting home buyer from filing objections. It strengthens majority rule through a structured representative process. So, majority decision, everyone has to abide, whether they are dissenting persons or whosoever. So, that is why the litigations are going less in case of these real estate cases. So, therefore, it is strengthening the overall structure. Then again, it enhances the transparency and accountability. It improves the inclusiveness of non-institutional creditors. It helps non-legal first-time creditors like senior citizens, low-income depositors, or apartment buyers to be a part of resolution decisions. This person guides them because legally you cannot make everyone at par, or maybe you cannot take, you cannot consider everyone is knowledgeable enough to understand the crucial aspects of this resolution process. So still, he takes time and conducts meeting, and he connects with the people, and that is more important. Cost effective for the creditors. Creditors don't bear personal legal cost. AR is paid from the CIRP cost. It is already mentioned. It supports real estate sector resolutions. So we all understand the benefits of appointing AR. However, there are limitations of authorized representative. Even if you have authorized representative, it's not that the matter will or the resolution process will quickly resolve. So there are some limitations of authorized representative. Let us discuss that also. So they have very limited role. They have no power beyond voting. AR cannot negotiate or challenge or initiate any legal proceedings on behalf of the class. It may create frustration among proactive creditors seeking stronger representation. There is a risk of miscommunication or passive representation. If the AR does not actively elicit views, for example, in case of Puneet Kaur versus KV developers, it can defeat the purpose of representation. Next limitation is discontent among the dissenting minority. Minority creditors often feel excluded or overridden because the majority decision will prevail here. Though AR must follow majority of voting share, it can create dissent and litigation. Then even the AR may feel that they are being paid low besides having so much responsibility. So fixed fees of just 15K to 50K per month are inadequate for handling thousands of creditors, especially in complex real estate cases. So this might also be one of the views or the limitations of authorized representatives. Next is replacement process. Still, it is procedural. Though a replacement mechanism exists, which require at least 10% support from the class of creditors if they want to replace the existing authorized representative, it is really hard to execute in practice for the dissatisfied members. Next is potential for perceived bias or collusion. If the AR is seen as too close to the RP or a financial institution, questions of neutrality may arise, even if unfounded. So there will always be a question in the minds of a class of creditors. They will be in doubt whether this person is biased or he's having any collusion. Next, over reliance on digital tools can exclude some creditors. Illiterate or senior citizens creditors may find it hard to vote via email, Google Forms, WhatsApp, and it might cause some kind of underrepresentation. Possibility of errors in voting collation. Errors in gathering, interpreting, or recording votes can lead to legal challenges or even scrutiny sometimes. So these are a few limitations of authorized representative. So broadly, if we talk about AR responsibilities in IBC, first is his class representation. He has to act in the best interest for the creditors. Regarding legal scrutiny, he has to prepare for potential legal challenges because he has to keep all the documents ready. Whenever any scrutiny or any kind of inspection is there, he has to produce those documents. Then he has to maintain proper records. Again, we have already specified that. He has to maintain accurate and transparent records. Then he has to be very transparent. He has to ensure open communication with the creditors. So all these are the responsibilities of authorized representatives. Then next, is there any reporting liability of this authorized representative to creditors of the class? So whether he has to report anything. The purpose of reporting is to maintain transparency and trust within the creditor class. What are the requirements? He has to circulate the agenda of the COC meeting. Then he has to seek voting instruction. He has to disclose COC outcomes, resolution, and vote results to the class post meeting. He has to document how vote was cast in alignment with more than 50% of voting creditors. So again, he has to justify his vote. Then if we talk about reporting to IRP or RP, in that case, AR works closely with RP, although they do not report formally like an employee. What are the duties? They confirm participation in the COC meeting. They submit voting results with evidence of instructions. They provide class level feedbacks if required by RP for plan formulations or COC clarification, etc. Then they are duty bound to keep the records and be audit prepared. So ARs must maintain all voting instructions received, communications made to the creditors, emails, letters, forms, etc. Proof of how voting instructions were collated, copies of notices, forms, resolutions, and class-wise voting logs. They have to maintain each and everything. These may be audited or scrutinized by IBBI as a part of disciplinary review. Even it can be scrutinized by NCLT if a class member challenges COC outcome. It can even be scrutinized by IPA as a part of compliance checks. Disclosure to IBBI or IPA. If required, they have to do that also. If involved in any complaint, appeal, or review, AR may be required to submit reports or logs to IBBI or IPA. Under the Code of Conduct, Schedule 2 IP regulations, AR must cooperate with authorities, disclose any conflict of interest, maintain integrity and independence in reporting. So what is the best practice which they should follow? They should always allow or they should always follow voting instructions exactly as received from the majority by the voting share. Maintain documentary evidence for every creditor's instruction. Never to take these things lightly because documentation is very, very important. Whether you are handling any assignment or you are just an authorized representative. You secure trackable communication channels. Treat all creditors equally. That means even pro or dissenting, you have to treat them alike. Keep timelines sacred. That means you have to follow the timelines. COC notices and plan communication must be prompt. Coordinate closely with the RP and IRP to avoid any gaps or information. So communication is the key, as we all understand. You have to, if you are in the shoes of authorized representative, you have to communicate regularly with the class of creditors as well as with the RP or IRP to keep a balance of everything. Now, there are some do's and don'ts for the authorized representatives. So, what he must do is he should understand the legal provisions, he should maintain the independence, he should communicate clearly, use the digital tools to handle the things efficiently. Otherwise, it will take a lot of time and energy also. Then, maintain proper documentation, both as per instructions only. That is the clear cut thing which one should understand. Clarify ambiguities, if any, and then he has to ensure confidentiality. He cannot just leak data to anyone, confidential information to anyone. So he has to maintain confidentiality also. Disclose conflicts of interest if there is any. He has to disclose that, and he has to stay updated for every thing which is happening in the resolution process. Next, don'ts. He should avoid these pitfalls. He should, or these authorized representatives should not vote based on personal judgments. He should not delay communication of agendas, minutes, or plans or details to any class of creditors. He should never force or influence the creditors into voting a certain way. He should not give his opinion, rather, he should try to gain others' opinion. He should not accept nomination or act as authorized representative without any AFA or IPA membership. He should try to avoid conflicts of interest. He should ignore dissent, or he should not ignore dissenting creditors or complaints from any class members. He should not bypass COC protocol. He should never misrepresent the position of the COC. He should avoid vague record keeping. He should not assume automatic continuance of his own position. So, because he can also be replaced, or he can be reappointed, any other person can be reappointed in his place. So, that is what he must take care of. Now let us discuss some case laws. I hope you all are with me. Lot of theory we have already discussed, and let us delve into some real cases and understand the legalities which have come across through these cases. So first case is Puneet Kumar versus KV Developers Private Limited. This is an NCLAT judgment. In 2022, it was reported. What is the synopsis of this case? The context is over 50% of home buyers, that is approximately 251 out of 473, failed to file the claims. The resolution plan allowed only 10% compensation for those who couldn't file in time. The key holding was the NCLAT deemed that excluding more than 50% of the home buyers from claims and giving only 10% compensation violated the fairness and Section 25A altogether. It directed the IRP to restart the claims process, elicit views from the home buyers via the authorized representative in true letter and spirit before COC decision. The actual, I've just reiterated the language here. The views of the financial creditors in class should be elicited by the authorized representative prior to COC meeting in letter and spirit of Section 25A. So it should not be just a formality. It should be actually taken care by authorized representative. So this case is very relevant for us to understand that AR must actively gather views, votes before COC meets, and it should not be just a formality. So he has to be on his toes and gather proper information. If there is such scenario where more than 50% of class of creditors are not responding, then obviously he should take some action, and he must act on his own. Next is Ashray Social Welfare Society and others versus Saha Infratech Private Limited. This is an NCLAT case again. Case synopsis, the issue here was whether an AR can contest claim rejection decision before NCLT on behalf of the creditors. Finally, it was held here in this case that AR's statutory role is limited to COC representation and voting, and he cannot claim verification or court representation. The financial creditors retain independent rights to litigate and claim. This is the actual wording which was there in the order. Authorized representative has a limited role to attend the meetings of COC and to cast the votes. There is no provision that AR shall represent the creditors before the adjudicating authority. So this case is relevant for us to understand that it has clarified all the unnecessary assumptions about AR's broader functions beyond voting. So AR's role is just restricted to voting. He does not have any other role beyond this. That means getting into litigations on behalf of creditors, etc. He does not have that kind of role. Next case is Ashmeet Singh Bhatia versus Rakesh Verma and another. This is a very recent judgment. The context here is that a single home buyer sought replacement of this authorized representative, alleging that he is misconducting or is having any collusion. The findings were that replacement of AR must follow Regulation 16A, Subregulation 3A, that is at least 10% of the creditors from the class must support the application. A single dissenting home buyer cannot unilaterally challenge the authorized representative. The actual wordings were, a lone home buyer cannot be allowed to question the voting by the authorized representatives on behalf of majority of financial creditor in a class. AR cannot be removed using inherent jurisdiction if clearly governed by clear statutory procedure. AR's duties remain strictly limited as per section 25A, that is attendance or voting as per instruction, etc. Authorized representative is tasked with voting based on prior instruction and not an independent decision maker. So what is the significance of this particular case? It reinforces that AR replacement process is statutory and collective, and it is not an individual process. AR can't exercise personal discretion over any matter. So on both the matters they have discussed regarding the role of AR, even if he's doing any misconduct, then also this case is relevant for us because he is duty bound to act within his scope. And then regarding replacement also, this case is very, very important. Moving further, this case I have taken at length, Earth Buyers Association for Justice versus Akash Singhal and others. This is an NCLAT order dated 31st October 2022. What are the facts of this case? The IRP was initiated against Earth Infrastructure Limited, a real estate company. Hundreds of home buyers had filed claims as financial creditors in a class under Section 21, 6AB. An authorized representative was duly appointed under Regulation 16A to represent the class in the Committee of Creditors, that is COC. A resolution plan was approved by the COC with 99.97% voting share. A minority segment of the home buyers challenged the resolution plan, claiming their interests were not adequately protected. So these are the facts of the case. What was the key issue in this case? The first issue here was the AR's vote valid and representative if not all the creditors in the class agreed with the resolution plan? Could a minority class of dissenting creditors invalidate a COC approved plan based on their dissatisfaction? This was the second issue. There was one more issue here. Did the authorized representative exercise voting powers lawfully and as per the statutory mandate? So, with respect to all these three issues, these were the NCLAT observations. The AR acted as per law, gathering instructions and voting in line with majority, that is more than 50% of the class of members who responded. The statutory framework does not require unanimity among all the creditors in class. Only the majority of received instructions are binding on the AR's vote. Dissenting home buyers fail to prove any illegality or misconduct by the authorized representative. The plan was found fair, feasible, and approved by a near unanimous COC vote, that is 99.97%. An authorized representative represents the voters of the class after taking decision by vote of more than 50%. Resolution plan have been approved by 99.97% votes, cannot be interfered with on technical or procedural grounds. This was finally held by NCLAT. What was the judgment? NCLAT dismissed the appeal filed by the minority home buyers. They upheld the validity of the AR's role and voting in COC. They reaffirmed that an AR does not need individual consent from all class members. Only a majority among those who had responded, that is what he has to look into. And this case law has set a benchmark for AR's responsibility and effectiveness in streamlining mass creditor participation in CIRP. So this case actually tells us why AR's role was very, very crucial, or why it is very fruitful. Firstly, efficiently, it has consolidated the opinions of a highly fragmented home buyers class. The role of AR, it prevents delays or derailment of a well-accepted resolution plan. It enables the majority will of the class to be properly represented and enforced. The role of AR enhances the credibility of the class voting mechanism under section 25A3A. There's one more case here which is worth discussing. Consolidated Engineering Company and another versus Golden Jubilee Hotels Private Limited. This is 2018 case. Quickly, I've just summarized it here. The adjudicating authority in the impugned order had held that 10% of the total debt for the purpose of representation in the COC is to be calculated on the basis of the claim as collated and noticed by the RP. NCLAT upheld the impugned order and stated that if the claim of the operational creditors on verification is found to be less than 10% of the operational creditors, have no right to claim representation in the meeting of the COC. If you remember, we at the beginning of this session only we discussed about that even OCs can have their authorized representative if their share is at least 10%. However, NCLAT allowed the representative of the operational creditors here to observe the COC proceedings, but without any right to object or participate in the said proceedings. And if any contrary decision is taken in such a case, the operational creditors may move proper application before the appropriate forum at proper stage. So since their share was lesser than 10%, they were not allowed any voting rights here, obviously, and it was just that they could participate in the meeting. Participating, they could attend the meeting, but they could not actually take part in the decision making. That was the final outcome of this particular case law. So let us discuss the difference between the role of RP or RP, and on the other hand, if we talk about authorized representative, what is the difference in their role? First is regarding the legal authority. We understand that RP is appointed by NCLT under section 16 or 22, while on the other hand, authorized representative is appointed under section 21 via form CA, and the whole process we have already discussed. What is the function of RP? He manages the debtors' affairs as a whole, conducts CIRP, handles COC, prepares resolution plans. So he has a wider role. However, AR only has a limited role. He represents the class of the creditors in the COC, cast vote on based on their instructions. Regarding duties also, RP have much wider duties in contrast to AR. So RP will collate the claims, constitute COC, run day-to-day affairs of the business, prepare IM, invite resolution plans, and a lot more. And on the other hand, authorized representative will just inform creditors of the COC agendas, obtain their votes, convey the decisions, circulate the plan outcome. So their duties are also restricted to the meetings part or the voting part. That is it. Regarding the communication role, RP communicates with all the stakeholders, whereas the authorized representative communicates only with the creditors of their class. Normally, they have that much role. Accountability. Directly, RP will communicate or they will be accountable to COC and NCLT. On the other hand, the authorized representative will be accountable to the class of creditors via NCLT and also NCLT at some point. Okay, so how can the collaboration of RP and AR result in a very effective resolutions? So, firstly, if we consider AR to be, a very helpful resource person for us, so that this kind of collaboration will help in reducing the challenges because there will be fewer abstentions and NCLT challenges will be lesser. Then there will be higher acceptability because AR is obviously a professional person and he understands the things and he will guide the class of creditors also accordingly and maybe make them understand the things in a very lucid manner. Then lower grievances will be there. There are fewer grievances and better trust if AR is appointed. For successful resolution, in case of real estate, NBFC, CIRPs, appointment of AR is very, very crucial. And therefore, there has to be a proper collaboration between RP and AR. Again, there are some points how you can maximize the synergies of both the persons to have ultimate value maximization. So first is the joint planning of the communication timelines. How it will benefit for the overall CIRP, timely voting will be there, decision making will be there. It avoids default abstentions also. Mutual support in addressing creditor grievances, then collaborative explanation of resolution plans, use of common technology tools, transparency in AR fees, disclosures and updates. This will obviously avoid conflict with other COC members. It will preserve CIRP cost and efficiency. So ultimately, it is a win-win situation for both the persons if you have this authorized representative in place. There are a few tips also for effective coordination. Firstly, you should have a proper communication. Schedule weekly sync-ups or email briefings of COC agenda, voting windows, and creditor queries. This should be properly communicated with the authorized representative. Establish a communication protocol, who sends it, what is sent, and how it is being done. So you have to establish that kind of structured communication channel. Then proper documentation of each and everything should be there. Share draft agenda and resolution plan with AR at least 72 hours before creditor circulation. Maintain a shared record tracker of votes, queries, and resolutions. You can use these digital tools like Google Sheets, CRM to track Form CA responses and all. Set up a WhatsApp group also, or bulk SMS or email systems can be used for proper communication. Then you can have joint question and answer webinars uh, through Zoom or Google Meet to explain the complex plans or the timelines. Then COC transparency. In case of COC, RP should always record the authorized representative's vote with reason and allow observation, not just numeric votes. So that is it from the theory point of view. If there are any questions, we are open for that.
Madam, the case laws we had discussed.
Yes, sir.
there was a challenge by the minority shareholders before the NCLAT against
Yes,
the AR, saying that he has colluded with the other group, right? Now,
yes, sir.
there AR has to defend himself in the NCLAT. There's some legal cost involved. Now, who's to bear that cost?
So according to you, who should bear?
For no fault of his and for the small fee that he is receiving, this is an additional burden for the AR. This is my view. So I'm talking from a practical perspective. Don't you think my submission is right?
Yeah, it's correct, sir. Because this case is on the person himself, so he cannot put that cost, saying that this is in the course of doing the things. So it's not in the ordinary course of business, I would say. So cost will have to be borne by the professional himself. But
Yeah.
if if at all, I mean. Since this judgment is there, he can always take side of this judgment, or he can. That is why this clarity comes from this judgment, that uh, these kind of things are not in his control, and if majority people are with him, then it is not. Uh, it will not be said to be his misconduct or collusion or something like that.
No, no, point taken. That is the ultimate outcome.
Yeah.
But when the case is before the NCLAT, he cannot represent himself. He has to go through some legal person.
Right. Right.
And that cost he has to bear. And for the fees, what he's getting, the retainership visa plus this, is it worth it? Number one. And secondly, second question, what I have in mind is whatever fee you're receiving and this sitting fees plus monthly fees you get, right? The
Right.
AR gets a monthly fee plus a sitting fee for each of the meetings.
Right.
So,
Right.
should we have to pay that 0.25% to IBBI for this? My second question is that. Now the
So
RPs
normally
pay. Now the RPs pay, no?
RPs pay, yes,
Commitment
but
fees.
it is only for the RPs as far as I know. I don't think from the
AR
point of
should
view
pay.
of
Okay.
authorized representative, we don't have to pay the share.
Fine, 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 fine.
Yeah.
Okay.
Also, the point will be mentioned in the form also, sir. Wherever you pay that share, you have to fill that form. In that form, I don't see that authorized representative role. Is it there? We can check it out also.
I've not
Anyone
seen,
has?
just for I mean, just for clarity, I just raised this issue.
Yeah, yeah. It's not there. And
Uh,
regarding that cost part, sir, as you were saying, very, very rightly pointed out, but he has to bear the cost on his own,
no,
because
all
here,
this, see, the IBWay has to take all these points into
yes,
consideration
yes.
before all this. Madam, your slide presentation preparation, it's very, you've done a lot of homework, a lot of thought process has gone through. It has been
So
excellent, excellent presentation.
actually, it
Thank
was
you.
a challenge for me how to take the session for 3 hours.
3 hours,
This AR
exactly,
topic,
exactly.
when this
Yeah, I
topic
know.
was given to me, even I felt what I can understand with this topic. I mean, what I can share
You,
with everyone.
yeah,
Even
you made it really interesting, and you've justified for 3 hours.
And still, I
I
have 10 more minutes to go. I have some more thing for you all. If you are ready to go with it, if you don't want to
okay.
cut short the session.
Okay.
There are a few questions for all of you, whether you have understood the things or not. So just let me share the screen again. Just allow me 1 minute. So in fact, after reading this, it just came to my mind that why not take this as a professional opportunity also. Just let me know if my screen is visible. I'm just making it full screen. Okay, so first question for all of you. Can an AR refuse to cast a vote if less than 50% of the class of creditors submit instructions? Now I need answers from your side.
No.
Can he refuse to cast vote? He has received lesser than 50%, but whatever he has received, out of that he has to make a point. I mean, whether majority uh, uh, voting is to be, I mean, whatever he has received, out of that he has to conclude. So that is the thing. So can he refuse? It is mentioned here that as per section 25A3A, if the instructions for creditors in the class representing less than 50% of the total voting shares are received, the AR must abstain from voting. Just like in the case also we discussed, if the representation is not of 50% people, it will not cater to a valid point. The final conclusion will not be feasible to all. So ultimately it will lead to litigation. So better to abstain from voting. That is the perspective taken here. So that is why the answer here it is mentioned. Yes, that even if he has not received the 50% people have not given their vote, or they have not casted their vote, in that case either he should communicate with them, the rest of the people. He should try to gain more, so that better clarity can be done, or better justification can be done by his voting at the time of voting in the COC meeting. The law mandates here that AR vote in accordance with the majority of voting share instruction received, otherwise no vote is cast. Next question. Can an AR file applications in the NCLT on behalf of the creditor class? I think this should be easy. Can AR file applications in NCLT on behalf of the creditor class? I received, I think, one answer in the chat box. Answer is given by DP Gupta sir. He's saying no. Generally, it's no, because we have just now read that his scope is very limited, just to attend the meeting, just to vote, nothing beyond that. So the AR's role is to represent voting rights in COC, not to independently litigate. However, in certain cases, for example, mismanagement of creditor information or voting rights denial, ARs have approached to NCLT to seek the directions, but only after COC or NCLT authorization. For example, NCLT in JP Infratech allowed AR to move applications related to voting procedural issues. Next question. What happens if creditors in a class change their vote after submission? What happens if creditors in a class change their vote after submission?
It cannot be altered, madam.
So regulations are also silent on this post-submission changes. But as per the best practice, if the change request is received before voting window closes, AR may update his record and accordingly he can vote. So that is the thing he can do. But after closure, no changes are permissible. Next, can an AR act for more than one creditor class in the same CIRP? Can he act for more than one creditor class? Legally, it's not possible because there will be conflict of interest also. So it's highly discouraged. Next, how does AR handle conflicting instructions within a class? So how does he handle any conflicting instruction? So AR aggregates instructions by voting share and not by the head count. So this is something we all should remember, that as per voting share, the instructions are aggregated. Even if 100 creditors vote yes and 90 vote no, The AR's vote will follow the side with higher voting share percentage and not simply majority count. Is AR liable for wrong claim admission by IRP or RP for class creditors? Is there any liability for AR for wrong claim admission? I think this should be easy. There is no liability of AR. Claim verification is purely the duty of IRP or RP. AR's role starts post class constitution and does not extend to claim adjudication. Next, can AR be replaced after appointment? I think you know the answer for this. Yes, he can be replaced under Regulation 16A, Subregulation 5. The COC can replace AR with NCLT approval if deemed necessary. Replacement may also occur if AR fails to act diligently, or if he loses eligibility, or if the creditors in class request any change. Next, who bears AR's fees if CIRP fails early? That is, if there is an withdrawal under section 12A. The answer is already in front of you. Since AR's fees is part of CIRP cost, it must be paid proportionately from the amount deposited for withdrawal as approved by COC or the NCLT. Next, how to ensure confidentiality when communicating resolution plan details to the class creditors. So basically, NDAs or confidential undertakings should be signed. These open group communication should be avoided. Preferable is to have one-to-one emails or secure portals. Then redacting can also be done. Sensitive information can be hidden, and thereby you can share the information. So this is the last question. Can AR communicate directly with resolution applicants? Can AR communicate directly with resolution applicants? No, I have received an answer in the chat box. No. Yes, the answer is correct. All interactions must route through IRP or RP to maintain neutrality and compliance with confidentiality provisions in Regulation 35(2). So that's it. We can wind up the session. If you have any questions, I'm open to it. Otherwise, we can just wind it up. From the admin team, if anyone is there. Thanks a lot, sir. Thank you. Okay, then have a good day. Wish you a very happy Raksha Bandhan in advance and enjoy the weekend. Bye.